So let's get to our rock star tonight, and because that's JD. And everyone knows JD, our county attorney, because he's really turned the county upside down in a very good way this time. But I want to read to you something that we received not too long ago from someone who works with JD. I don't know if you've seen this, but I have permission to read this.
I heard about it.
You heard about it. I know you hear from outside sources. JD is doing wonderful things for the county, but I'm guessing you haven't heard directly from an internal source what it is like to work in his office. JD's attitude and demeanor is one that keeps everyone in our office excited to come to work. His integrity, enthusiasm, and work ethic is well respected, and the staff feeds off of it. JD holds high levels of expectation and pushes his team to strive for excellence. But equally so, he praises and recognizes individuals publicly, and the employees never doubt that they are appreciated. He has created an environment in our office that is new territory for many of us, including myself. JD maintains an open door policy and is available for any staff member at any time. He is trustworthy, honorable, and just an all-around good man that cares about people. It goes on. The impact the PAC has made by getting JD elected goes far beyond just county business. People's lives have actually been changed. JD may be known for his active part in Joe Corley mental health, that ordeal, but on any given day, he meets personally with victims of juvenile crimes. He takes the time to talk with applicants for protective orders. He goes to CPS court to support the staff on important termination cases. He attends mental health dockets, almost every civil service hearing, and always stays up to speed on all pending litigation cases. You can catch him helping a staff member fix their computer, move furniture around in the office, or help organize the supply room. No job is beneath him, and he treats everyone with equal courtesy and respect. I have to remind him to take a lunch break or when we have a county holiday. He's a workhorse and never stops. He loves what he does and loves serving the people of this great county. We are so pleased to have you here. I'll turn it over to our county attorney. No, this is probably better safe. That's pretty awesome.
Yeah, I think I spelled everything right.
Well, I'm missing one part here someplace. Here we go. Well, thank you very much. I had no idea Julie was about to read that. I had heard about it before, and I probably shouldn't say anything now because I can only go downhill from what those comments said. But it's great to be here tonight. I would like to recognize Ricardo and his lovely wife. We were out there Sunday evening at a Cinco de Mayo celebration in downtown Conroe. A group of, I think there was about 8 of us from the Republican Party helping out and passing out constitutions for the people out there. Big Cinco de Mayo celebration, and passing out constitutions in English and in Spanish, and a sheet that had been prepared comparing and contrasting Democrat and Republican side, and both English and Spanish also. And people were readily taking those, and your help was greatly appreciated. I think there's like 8 of us or so doing that. I think everybody gets from my preaching choir. If we don't continue to make efforts like that to bring in other groups, Hispanic groups and so forth. I don't know how many people were there, maybe a couple hundred or so at that time. A terribly estimated crowd. Yeah, so anyway, well, thank you much. It's my pleasure to be here. I'm so glad that Brett Ligon, how many of y'all heard Brett here 2-3 weeks ago or something like that? Oh, only Brett heard himself. Well, one thing I really need to do, there's a myth out there that's spreading that Brett is my older brother. It's not true. He's not my older brother. I'm the one with the curfew that has to get back to the home at night. Brett reminds me. Let's see. Well, I said I didn't need a mouse pad. Now I don't even do that. Well, I didn't before. before, but now suddenly, you know. I'll say it. Yeah, that wasn't either one, sure. Let's try this again. Sorry for this test. There we go. Okay, well, as Julie said, those of you that, maybe everybody knows me, but those of you may not, I was elected in November 2012, took office January of last year, so we've got about 16 months under our belt as a county attorney's office. And I found out during the campaign, hardly anybody knows what the county attorney does. Most people know what the DA does, but not what the CA does. So we'll touch on that a little bit tonight as well. And I've decided, in the interest of time, I'll take any and all questions, but in honor of Walter, we're going to take questions alphabetically by first name. We'll get to you, Walter. I'm sure we'll get to you. You heard it here. So anyway, so let me just tell you just a bit about the county attorney. As you heard from Brett a couple of weeks ago, he has 90 or 100 people in his office. So we're about a third that size. There's about 30 of us, about 15 lawyers, about the same number of legal assistants. I've got a victim assistance coordinator, actually, that I borrowed, stole something from Brett. He's got a dozen of them he can spare. And then my admin manager, some of y'all I think I've met before. And then I have 2 investigators. They're police officers just like any other police officers. So that's who's on the staff. I also should say too, despite the fact that Brett's office is 3 times our size, we really support his entire office. We bear the weight of his entire office, because I'm on the first floor of 207 West Phillips, and Brett's on the second floor. So we're holding up the entire office. Okay. So what do we do? And kind of in short, the county attorney's office is the chief legal advisor for the county, and not for the county citizens, but all of county government, which gets rather large at times. There's around 2,200 county employees, and we're the legal advisor for all of those. So we're the legal advisor for commissioners, commissioners court, the county judge, all of our judges. When somebody sues the DA, the sheriff, our district clerk, or anybody, we defend them in that case. And there's no shortage of people that seem to like to sue the county and our county officials and our department heads. So we're the one that step in, and sometimes we have to take a little different tack if we're having to go against one of our sitting district judges, which we have done a couple of times. And in that case, we protect the county's interest. So we don't, we're not, our client in that particular case is not the particular judge. So on the screen here are some of the examples of the things. I'll step over here. They're not getting over this, so it'll go crazy. Some of the things we do. We handle all of the civil litigation for the county, both in state court and federal court. Most of those are in federal court, but a lot in state court also. As an example, we just resolved a case that actually started 3 or 4 months before I took office. A lady whose husband just happens to be a federal prosecutor that likes to go party while he's out of town. She was at a bar and claims our sheriff's department officers who were working there in an off-duty job had roughed her up, and she files a federal civil rights case against the county wanting billions of dollars. And this is one thing I think we've done in the office is change people like that perception of what this office does. One, the county typically would farm that litigation out and have outside counsel handle it. We've only farmed out one case since I came into office 16 months ago, and that's because an individual sued about 12 of our law enforcement people and sued the sheriff and constables and so forth, sued them in Washington, D.C. And just so happens I don't have a lawyer on my staff licensed to practice in Washington, D.C. So we had to pay $10,000 and got a retainer of a Washington, D.C. firm. And with us working together, they're the ones that has to appear in court. We had that case resolved in a couple of months, and it was thrown out by the court. But all the other cases we handled inside, which saves the county, thousands and thousands, of dollars compared to what they were paying previously. Other civil litigation thing, for example, I got a call yesterday afternoon about 3 o'clock. There was a fatality car crash north of Willis. Happened to be one of our precinct 1 trucks, and a lady coming down 75 from Willis crossed the center lane, weaving all over, and crashed into a county vehicle head on. Unfortunately, her vehicle caught fire and the lady died in that crash. But I don't expect a lawsuit out of that. It's very clear she was clear in our truck's lane. But if there is, we'll defend it. Commissioner Nowak, who a lot of you know, here a couple months ago, I guess now, one of his dump trucks flipped over, a loaded dump truck, and I think there were 5 or 6 different vehicles involved in that and some property damage. So we're handling all those claims. So we get involved in all sorts of things. Juvenile prosecution, I'll talk a little bit about. I'll touch on some of the specifics of these, but last year we handled just over 1,100 juvenile cases, and whether it's like a Class B misdemeanor, a kid getting in a fight with a classmate, or graffiti on a school wall, or a case that we just went to grand jury today on a capital murder case. We prosecute all of them, juveniles from 10 to 17. Older than that, then they get handed over to Brett's office. Contracts, you can only imagine how many contracts the county must be involved in. I wish we reviewed all of them. I think the county would be in a lot better shape if we did. But a lot of these things happen and we don't even know about them. But we're trying to look at as many of the contracts as we can, because when I came in, we pull a contract and the county has agreed that if there's a dispute on this contract, venue is proper in Michigan. And if you're not the prevailing party, you shall award attorney fees to the other side. We would never agree to either of those things in a contract. So we're trying to clean up a lot of those things. Of course, we can't go redo the old ones that are that way. An area that is far surpassed what I thought we'd get involved in: employee grievances, terminations, anything labor and employment. I've got a fine labor and employment lawyer that I brought in. She was a shareholder in a Houston firm. And this is one example where we've kind of put ourselves out there, because it's one thing if you want to get your clients out of trouble. I told him what I like to do is keep you off of the front page unless it's good, and usually it wasn't even good. And we'd like to try to keep you out of trouble before you ever get in it. And people have learned that. Our constables, our tax assessor, our sheriff, you name it, they now come to us on the front end of a lot of these labor and employment cases. And I mean, they're just like coming out of the woodwork when you got 2,200 employees. And so it's very helpful to have somebody that really knows and understands all the ins and outs of labor and employment law. At any given time, we probably have 8 or 10 of those cases going on. It's just incredible. Real estate transactions, those are occurring constantly. The big ones, of course, that made the news was when the county sold the Joe Cordy Detention Center last year. Gosh, I lose, it's been so long now, $60-something million sale. The county before was using a law firm out of Houston to handle all those kind of things, and they were billing the county per lawyer $850 an hour and about $300 an hour for their legal support staff. We handle that entire transaction with my staff. This isn't me, this is my staff that does this. I just set the tone, get the right people, and get out of the way. It's hard to say what we saved on that, but I would say $100,000 or so we saved the county, and everything went off without a glitch in that whole transaction. Mental health cases, those come in our office every day. Somebody comes in, their brother, their husband, or whomever has some mental issue, they think they're a danger to himself or to others. So we go through, we interview them, make sure it qualifies. So virtually every day mental health cases. CPS cases, we have about 400 of those a year. And in fact, my team just finished trial about 5:30 last Friday. We had a 5-day jury trial, a CPS case, 6 parties involved. And we vigorously fought that case. We were trying to protect a 25-month-old child from a mom and dad who are methamphetamine users and other drug users. And it was a vigorous fight in front of a jury. We hadn't even rested yet. We were going to finish our case by the end of the day, or maybe this past Monday morning or yesterday morning. About 3:30 Friday afternoon, father's attorney capitulated, and we got everything we wanted, although we spent 5 days getting there. But we protected that little child, and it's not going to be back with the mom or the dad until someday down the road, if and when they clean up their act. Open records requests. Our sheriff's department gets about 12,000 of those a year. It's very important to have open government and so forth, but until you're in the midst of it, most people don't realize just what's entailed in doing that. So anytime the agency gets an open records request or a freedom of information request, if that agency, sheriff's department, county clerk, tax assessor, whomever it may be, if they think they can release that information, they release it and we don't get involved. But if they think some of that's protected, then it comes to us. And we had about 800 of those cases that we handled last year. Previous to my coming in, apparently every open records request that came in and got referred to our office, county attorney's office just sent it off to the AG and let the AG deal with it. And so months would go by waiting on an AG opinion. So you're paying our staff, the county attorney's office to deal with it, paying the AG's office to deal with it. And so many times by that time the need or the desire for the information is passed. And so we totally changed that in my first couple of weeks in office. We rapidly respond to those as you're required to do. And if there's things we know the person who's requested the title to get, we give it to them. If it's something that's protected, typically like an ongoing criminal investigation, we can protect that. But otherwise, it's much more open. And then finally, protective orders. Hardly a day goes by we don't have somebody come in, more often than not women, but not necessarily women, in an abusive relationship where it's a family member or a boyfriend, husband, whatever it is. So that's a pretty good example of all the kind of things we cover. And one thing that really makes us different, I've come to appreciate, say compare the DA's office, they prosecute on thousands and thousands of criminal cases, both misdemeanor and felonies. And they're able to move people around, people move from court to court and move up in the court system. It's much more difficult here because I'm not going to take a real estate guru and suddenly he's going to go try a CPS case. I mean, I could get him up to speed to do that, but be a very ineffective use of people. So you end up with many more specialty areas in the county attorney's office. I want to touch quickly on some of these. A lot of people have heard, how many people have heard about the TexCom, the toxic injection well case? Looks like maybe half of you heard that. I'll touch on that briefly. There's this case I mentioned a few minutes ago. I really won't say anymore. This Roberts excessive force case. That's the lady that's at a bar and then goes out in the parking lot with other guys. And when she came back into the bar, her clothes were inside out. And suddenly it's the cops that roughed her up, you know. But that's the one we spent almost 18 months, Daniel Blake in my office handled. And it's supposed to go to trial next week. The plaintiffs dropped their case last Thursday, I think it was. And that's the reputation we're sending. We're not going to farm these out, and we are going to vigorously. And previously, the county, I guarantee you, the county would have written that lady a check, $100,000, $150,000, whatever, just to go away. She did go away, but for zero money. And that's the message we're trying to send. If there ever was a frivolous case, this one really was. And then we'll talk a little bit about this potential case involving the construction of those two facilities, Joe Corley and mental health. And I want to touch quickly on a couple of juvenile cases. So let's talk about that toxic well case. One thing I realized when we talk about it, I don't think I've ever shown where the heck that is, because it's really in your backyard. If you live in the Woodlands, which is right down here, this is the old Conroe oil field. Those wells were drilled back in the 30s. And a company called TexCom has a disposal well out there. They have about 30 acres in that Conroe oil field. And they have a disposal well, and they want to drill 3 more and inject hazardous liquid waste into that well. Well, the problem is there's about 1,100 what I'll call straws in that old Conroe oil field, because that's about how many wells are out there, starting in the 30s and 40s. And those casings are rusted, a lot of them not been plugged properly. Plus, it's still very much a producing oil field. Chances of major recovery out there with the operator now in that field. So TexCom wants to come in and inject that toxic waste in there. And the big concern is with all of these wells drilled, like I say, over 1,000 of them, that waste can migrate up the formations and into the water supply and pollute the water supply, the aquifer for miles and miles and miles. That case has been going on long before I came on the scene, about 6 years, maybe 7 years now, and I've been following it really since its inception. And seemingly Texcom will spend any amount of money and do anything to try to win the case. Now, my office, my predecessor had farmed that case out long before I came on board. The case is about 7 years old now. So it's an Austin law firm that's handling it because the suit is in Austin. But now we are heavily involved, more of a partnership arrangement with that. But you see, it's about 8 miles from the Woodlands. I mean, just outside of Loop 336 right there in Conroe. So this is really in the backyard of people, live in River Plantation and areas like that. So something we really ought to be all concerned about. There's actually 2 Texcom cases now. The old case has been going on. I wasn't in office yet, but in November 2012, oral arguments in a piece of that case is on appeal in the Austin Court of Appeals. So I went over to Austin so I could hear firsthand. That was in November of 2012. More than a year and a half now, the Austin court has never issued a ruling yet. Now, if this case was here, it was on appeal in Beaumont, they would have issued their ruling a year ago or so. Beaumont court is very efficient, very effective court. Austin court is notorious for being backlogged like crazy. So who knows when we're ever going to get a ruling out of that court. And of course, Texcom has a big name law firm, Bracewell and Giuliani. Mayor Giuliani, you've heard that name. So they've got big guys, but they put on their britches just like we do. And we got big guys in my office that they can handle it. So what did Texcom do a few months ago? They decided, well, we're going to sue the county because we've sued them to try to stop this well. So what they did is sue the county and sued all of our commissioners, our county judge, and the county. And so we're defending that case. They filed that suit in federal court, claiming we have violated their constitutional rights. And essentially, and I don't want to get into the nitty-gritty, but essentially, you've taken my property away. I wanted to go inject these liquids in there, and essentially it's a takings thing. So we're vigorously fighting that. In fact, we just filed another response this week. So we're hopeful we'll get a favorable ruling in that case on the federal side. Federal courts move far, far, far faster than some of the state courts. And so let me talk a little bit about the whole Joe Corley mental health case, mental health treatment facility case. And that's where the complex is. Here's Loop 336, north side of Conroe, Highway 105, Conroe Airport. So that's where it is, just right on the northeast side of Conroe. And show you just an aerial photo here, because these facilities, and I didn't glue these pictures together, that's how they physically sit on the ground. So on the far left is the Montgomery County Jail. Tommy Gage is the sheriff over that. Round number is about 1,250 inmates, and it is virtually at the capacity. One day, about a month ago, I think it was 1,235. I think they had like 15 positions left. So that's where Joe Corley is. Right next to it, that's Montgomery County Jail. Right next to it is what's called the Joe Corley Detention Center. Joe Corley was a sheriff in Montgomery County years ago. That facility was named after him. It's a similar size facility, around 1,200 or so inmates. It's only been used since its inception to house federal inmates from ICE, Immigration Customs Enforcement, and U.S. Marshals Service. So it's just housing federal detainees. And it has been run since its inception. We don't own it anymore, I'll touch on that. Since its inception, it's been run by a company called GEO, who is a big, big player in the prison business. They've got 20 facilities in Texas. They're all over the place, so they're a big time outfit. And then sitting right next to that is the mental health treatment facility. And what that facility is, because I hear this time and again, oh gosh, you guys, you're going to sell that facility, and what are our mental health people going to do? They need care and treatment. It's not what that facility was ever designed for, not what it's being used for. As it turned out, it's got 94 beds. It was supposed to have 100. But everybody in there, and it stays at a capacity of about 90, those people all come in there as prisoners from counties all over the state of Texas. And a judge somewhere, wherever their criminal case is, has deemed them incompetent to stand trial. So this is one of the places they can be brought to to try to get them competent to stand trial. And then once they are deemed to be competent locally by the physicians and so forth out there, they go back to wherever they came from around the state and take care of their criminal business. So that's who's there. Yeah, Brett.
How many of them are there from Montgomery County?
I don't know if I had that. Let me see if I had that. I don't think I have that slide over here. Interestingly enough, the last time I pulled the stats, which kind of blows me away. I don't understand why this facility is here personally. Only 4% of the people that have ever been treated at their mental health facility, only 4% of the people who've been treated there are from Montgomery County. And one of the things it was sold on, well, this will save our law enforcement for having to transport people up to Rusk. It will save that time and expense. It's just not happening at all. Inmates are coming there from El Paso County, from Tarrant County, Dallas County, Bexar County, all over the place. And only 4% historically have come from this county.
And ours are being shipped out of this county.
Yeah, we have a lot of ours being shipped out. It defies any logic. I don't understand. One thing now, that's an aerial shot of that facility. Just made a note there, if you see anything unusual, you may not see it from that figure. One thing that starts to give it away, it's kind of got a circular perimeter fence. And gosh, it looks like the fence kind of starts to go straight for some reason. Well, the reason that is, each of those wings has 20 beds in it. The contract call for that commissioners entered into was going to be a 100-bed facility. That wing on the left looks a little short, and it only has 14 beds. So what the county ended up for their $38 million was a 94-bed facility, not a 100-bed facility. It was also supposed to have 8 infirmary beds, which are not permanent places where they would stay. Somebody's being treated for some medical issue. So instead of 100 patient beds and 8 infirmary beds, what the county got was 94 patient beds and 6 infirmary beds. And there's what the deal was. There's a little cleaner look at it. I mean, if nothing else, you just count the windows, and you can see that wing is short over there. So that's one issue when you hear about the cost of the facility. And again, the county paid about $38 million for it.
That's what the whole thing is about.
Okay, that's what I've already said there, how it was as built. One big thing where the county, in my opinion, got taken to the cleaners $2 million before any work was ever done on that facility was work had already started. One of the former commissioners was kind of spearheading the project. He was the go-to person on Commissioner's Court, along with our former auditor. They were the project leaders, project managers, if you will. Now, I'm not saying the rest of the commissioners didn't go along and vote unanimously for everything, but they really put their trust and confidence in those two. And that's why we've singled those two out, because they were in a totally different position. So they had started work, planning and everything of this facility before any contract with the county was ever entered into. And there's a sister facility to this in Florida. So they traveled to Florida to check it all out. That makes sense. But Florida standards required that the mental health facility be built to prison standards, because the people going to be housed there all come here as prisoners, as inmates to be treated. And so that's the reason they came up with the number. It's going to be $38 million, and then that contractor, Alliance Development, which was headquartered in Shenandoah, they've now shut down their offices. So they got bids and was going to build it to prison standards. Well, then once the thing, and still no construction had been done, and then it was determined, no, the State Department of Human Services didn't require it to be built to prison standards, which you can imagine are a lot more stringent. It's built like a jail instead of a hospital. And the state said, no, just build it to hospital standards. So Alliance Development, the developer, which I have no idea why we have a developer anyway, but we did, went back to his general contractor, and the general contractor lowered his estimate by $2 million, $2.1 million, I think exactly, because you don't need all these secure things that you're going to have in a prison. And the way the contract specified, And it's not as though because the developer just sharpened his pencil and beat down on his subs to get a better deal. They just redid it because it's going to be a hospital. It's not going to be a jail. So the general contractor that the developer's working with lowered his bid to the general contractor by $2.1 million. The contract says any savings like that comes back to the county. Unfortunately, it didn't happen in this case. The $2.1 million went in the developer's pocket. County didn't get any of that back, and we're getting no signal here. So as I say, the developer kept the $2 million. That developer now, his home, unless he sold it recently, his home was in the Woodlands, about a $2.5 million home, but now he's choosing to live in Hawaii in a property that's listed for about $5 million in Hawaii, and I guess just to protect himself a little bit, not too long ago, he put that name, the title to that property in the good friends of his house, in a good friend of his name. So that's the kind of games these people play. So his $5 million house in Hawaii is actually showing it belonged to somebody else. In reality, it doesn't. So there was $2 million, and sometimes we use the word low-hanging fruit. That $2 million, I mean, it's hard to imagine how that's not owed to the county. And so we went to Commissioner's Court, I forget what month it was, now it's like it's November or something, and we presented a summary of our findings about how the county was taken on the construction of these two facilities. And we got a unanimous, so we have those discussions in the executive session. That's the only time we can talk to our clients, in this case, Commissioner's Court. And then they have to come back out in open court to take any action. They can't take any action in executive session. And then we came out there and they had signed a unanimous resolution giving my office full authority to pursue any and all claims regarding the construction of those two facilities, up to and including litigation. And we made sure it didn't specify claims against whom, because anybody we find, whomever it may be, would let the chips fall where they may. So we had that unanimous resolution. And then our investigation continued, and I don't know if we got a little close or what. And at a subsequent meeting, this is the article right out of the Courier there, and Commissioner Metter, a current commissioner, made a motion to rescind my authority to go against Ed Chance, who was a former commissioner that spearheaded the project, and Linda Brazil, who's the former county auditor. And he wanted to rescind our authority to go after them. And of course, Commissioner Metter had worked very closely with those people for years. As the Courier reported, silence fell across the courtroom. There was not a second to that motion. So we still had that unanimous authority, but it will come back, and I'm sure they're going to try to stop us. But we got a new court coming here in a few months. Like one of the gentlemen in the room here might be on that court here in a few months. So I do know that some of those commissioners are still, going to try to stop us from doing that. And that's about the only thing commissioners can do to me, is they control our purse strings. They can't tell me who to fire, hire, what they do, anything else. But if the county gets sued, we have to go to Commissioner's Court for authority to defend that suit and incur expenses defending it. And there's been dozens and dozens of those kind of things. And I mean, it's just immediately unanimous. Yes, do whatever you got to do. Until it came to this case. And for some reason, they're a little concerned there. But it's not because it's not a good case. So that's what that one is. The current status, one thing we've been wrestling with, and we talk about this a lot in the office, how to keep this out of the political arena, because no matter what I do, somebody's going to try, well, you're trying to influence the outcome of an election. I can care less about what impact, if any, this may have on the election. But some of the people involved are running for office. Some of them are still, they're all still in the court except for one. And trying to figure out, okay, what are they going to do to try to stop us? And so we have met with the attorneys for the developer. He's hired a big name, or actually two law firms in Houston. We've met with them, and of course they're not going to agree or admit to anything. And we had anticipated everything they were going to say. One thing they said, well, sue our client if you want to, because he's just going to file bankruptcy, and then you can go down the street and fight this case in bankruptcy court. So that's the tactics these kind of people use. And just, like I say, close down their office down here in Vision Park, just a little south of here. We've still been trying to arrange a meeting as, and I'll tell you what, this is what's out there publicly. Commissioner Chance's attorney has admitted this, it's been reported in the paper. So this Alliance Development was paid, in round numbers, about $75 million to build Joe Corley and build a mental health facility. At the same time that the county is handing Alliance Development, who's owned by Jim Galloway, $75 million, Alliance Development gives Commissioner Chance $500,000 in a series of payments. That's well established, and they acknowledge that. But their excuse is, well, that was a real estate deal in another county, so it shouldn't, no harm, no foul. Which, does anybody think that's the right thing to be doing? And what they did, he up in, I just don't, I forget the county name. Anyway, the county up north here bought a boat storage facility and improved that. And that's where all the money went. And of course, now he claims he's paid it back, and he sold that facility to a neighbor a few blocks from his house. So you see that. And then finally on Linda Brazil, she was the long time county auditor. She retired now about 7 years ago. When she retired, I believe she was making $110 or $120. I think she was making $120,000 a year. She retired. Essentially, the next day, she's hired as a consultant for these projects and stayed on as a consultant for the next 6 years. And she was averaging around $175,000, $180,000 to do those. She was paid $1.2 million. So the only claim we made against her, we poured over every one of her timesheets and extracted everything she had done on the construction of those two facilities. And so the county paid Ms. Brazil $240-something thousand just for those facilities. So he said, just give us the $240,000, you keep the million. And of course, she's not willing to do that either. And we weren't her only client, so she's getting retirement from the county. She got $1.2 million from the county for this work, plus she has other clients. So that's the nature of what that case is, and that's why these letters, that demand letters, which you typically do in any civil case, went out requesting about $10 million from, the rest of it from Alliance Development. They provided the county documents at the time of the contract of how much all these different aspects were going to cost in the facility. For example, they provided us documents to say the architect fee was going to be about, in round numbers, about $2 million. So when you add it all up, including the other $2 million, they got 38. But once we got our hands later, much later on the documents, what they really paid the architect was about $900,000. But they billed the county about $2 million. Now, Alliance has got to make a profit. We don't have a problem with that. But when you go through, and we have poured over the paperwork, they were moving money around all over the place to conceal what was going on. And it is not easy to see. One of the attorneys on my staff, about a 10-year lawyer, she's also got a master's in accounting and a tax specialist. And so we have poured over all of that. And they would take something that they're getting charged, say $300,000. They could do this routinely, they'd double it and charge the county $600,000. Again, is that a fair profit? So it was what's called a design build contract. They contracted to do it for a fixed price, but then they documentation. Here's where that price comes from, and it was, we say it's clearly fraudulent what they did. Are we ever going to recover money from that? I don't know, because there's so many games these people can play to try to hide that. So, just give you an idea on the juvenile prosecution cases. Last year we had 1,107 juvenile cases. So far this year we've had 413. So if you could just project that, and that may not be a good projection, you can see we're going to be over 1,200 juvenile cases this year. I want to touch base, just to give you some idea, as you've heard so much about Joe Corley and all that. This is one that fellow we prosecuted here. He was 16 years old at the time, and he was a babysitter for a young relative of his, a 6-year-old male, Mr. Sligdenhorst. I can say his name, show his picture, because he's now being prosecuted on the adult side, so we can disclose that information. We charged him in my office, I think, with 46 felony counts. And it's just what he did to this 6-year-old, I don't know if the kid will ever recover from the emotional and mental trauma he went through. But that gives you some of the idea of some of the kind of things he was doing. So we, because of his age, we sought to have him certified to stand trial as an adult. In juvenile prosecution, a lot of that is about rehabilitation. You get some young people that do stupid things and then get on right with their life. Mr. Slichtenhorst is not one of those people for the things he had done to this kid. So we had a 3 or 4 day certification hearing in front of the juvenile judge, and we're asking that he be certified to stand trial as an adult. If we prevail on that, then he gets handed over to Brett's office, and they prosecute him as an adult. And we won that back on October 29th. So he's now facing 5 to 99 or life, and his trial comes up sometime this summer. I don't think you are making him any offer at all. It is that egregious of a case. Keep in mind, he's babysitting his nephew. So he was also taking directions from older guy in North Carolina and Florida and stuff. You know, they trade these things on the internet. Hey, I like this. If you can get me pictures of this, I'll give you pictures of that. And it's sickening what they do. And there are some very young ones doing it. This case, this is the one I kind of brought back from the grave, I guess. This little boy was Robert Middleton. He was 8 years old. This is back in 1998. And a neighborhood boy of his, who was 13 at the time, set him on fire. And I've got a couple of 3 photos here that are pretty graphic. I'll tell you maybe the next slide. But I think it's important to realize, because people ask, well, why did I go after this case? Because it happened in 1998. And in 1999, my predecessor dismissed the case. They kept the perpetrator locked up for about 6 months in juvenile detention, opened the doors, let him go, and the case went away. And so I met with the family, with Robert's family, who now live in Galveston, because their whole lives essentially spent at Shriners Burn Institute. Nobody thought he'd live more than a day or two. Somehow, he lived from the time he was 8. By the way, he was set on fire on his 8th birthday. And he died just before his 21st birthday. And I have no idea how he ever managed to survive. But I have to give a ton of credit to the Montgomery County Sheriff's Department, the cold case squad, because my predecessor invited me in, and I think it was October or so before I took office. That'd be in late 2012. And I was briefed on the case, and he brought me in because he knew I'm going to inherit it if we're going to do anything. And I just told him my words then. I remember you might have been in the room. I think you and some of your people then. I said I'd rather go to bat and lose than to never go to bat at all, because these people never had their day in court. And there was compelling evidence against this kid that did it. He was 13 at the time. His neighbor is. There's the bad guy there. That's what he looks like nowadays. Don Collins is his name. Another terrible thing that happened that should have never happened. 2 years after he molested this little boy, oh, and by the way, that's really one of the things that was going on. Mr. Collins likes to sexually assault young boys and some young girls. And so he had done that to Robert Middleton and had set him on fire to try to cover that crime up. 2 years later, Don Collins sexually assaulted another boy who was also 8 at the time. So Collins was about 15 or maybe 16 at that time, over in Liberty County. And we brought that victim back to our trial. We had almost 30 witnesses in our certification trial. Huge, huge legal hurdles. And this case will go on for a long time, probably end up in the Court of Appeals. And we were determined to give this family some justice because they had never had their day in court. So because of that other assault, he's a convicted sex offender. And he now has 2 convictions for failing to register. And we located him, and there was a warrant out for his arrest in San Jacinto County for a 3rd time to failure to register. So we located him, let San Jacinto County know, and so that's in 1998. I won't get all the legal because it gets a very complicated legal matter. He was facing 3 to 40 in the juvenile system. That's all he could have been sentenced to in 1998 when it happened. So there's Robert Middleton at the time. I'm just going to show you the next picture here. If anybody needs to look away, that's what happened to him. He was set on fire. The only part of his body that wasn't burned is about a quarter piece on the bottom of his feet. And later in life, that's what Robert looked like as an adult. And it's amazing. I never got to meet him. He passed away. I never got to meet Robert. But the outlook he had and how he had worked past this. But he eventually died in 2011, I guess it was. And so what we did we had this 4-day-long proceeding seeking to have Colin certified to stand trial as an adult. And that may seem strange because he is an adult. He's 28 years old now. But when he committed, he was 13. So after a lengthy hearing, the court agreed with us. So we were successful, and he will stand trial as an adult. And I believe you are. And so that means we hand it over to the DA's office. And I think next week is my understanding. Next Tuesday, May 13th, it goes before a grand jury. And I think you are seeking capital murder against him. Got a lot of complicated legal issues. Good news is he's locked up. We've had him locked up since, I think, April of last year. So he's not out there hurting anybody else. It's not an easy case, but so far we've managed to do what I told this family we would do and try to get them justice. And so huge success on a very, very old case. I won't get into let's get into some of the legal things we had to do, the law changing during that time. And so Brett will now prosecute the case. Yes, sir.
On that case, that's still going to go to the appellate courts. As I understand it, it won't go to the court of appeals on the criminal route, eventually the court of criminal appeals on it. But the whole certification is still under question because we changed the law. It's still going to go on 50, maybe 3 or 4 years before this. Am I right about that? I'm not right. Well, isn't that something?
Well, the good news is, as I said, Mr. Collins is locked up. He's not harming any other kids or any other adults. And he has not been sentenced to anything. He's not been found guilty of anything. We just got where he's certified to stand trial as an adult. They cannot appeal that case at this point until such time as he goes before grand jury next week. They'll have a trial first of next year, whenever it may come up. And one thing the judge has already indicated, by the way, it's staying in the same court where we got him certified to stand trial as an adult. So, as I said, the most he could face was up to 40 years, as opposed to 5 to 99 or life.
Which is why we're back to capital. We're trying to change the range of punishment. For capital crimes, because the 340 for certification was under murder duty.
Right.
We're going under capital murder duty, so we try to get them to the life. So of course, capital life, non-capital life is 40.
Right.
40 versus 20, which is going to go for 40%.
But I gotta ask Mr. Lincoln now, I'm on the spot. Is there not a real question on this certification and what went on? I'm just talking legally, but it's very important. Are you gonna have a problem once you get it indicted?
No,
Then you'll get it indicted, you'll try it, and then the whole thing will go up on appeal, which will go back and question this certification. Unless the defense lawyer goes in there and gets some sort of mandamus against you before the criminal appeals. What do you think about all that? Never.
It's a complex case, may set some legal precedents, but I did what I said we was going to do. We're going to bring him to justice, and he's locked up, and now Brett gets to deal with the guy. So. Very successful. And I have to give one thing about it. I have a juvenile prosecutor that spent, I think, 13 years as an appellate attorney in Brett's office. He's been a juvenile prosecutor office for about 3 years now. He is one sharp lawyer, and trust me, we looked at all the appellate issues and so forth, so he was fully prepared. What may happen down the road, I don't know, but...
He's so good, we're deputizing, and he's going to work with us on the trial. So we're using the assistant county attorney. I'll deputize him as an assistant district attorney and try the case with us. Because he's been with the case since the case
What's his
was
name?
It's Mark Brumberger, one really fine trial attorney. He's about a 15-year lawyer, I guess, right now. But One fine addition to county attorney's office. So anyway, I want to just open it up if there's any questions that kind of gives you a flavor of everything that goes on, what we're doing. Oh, by the way, another case we're dealing with, and we're working together with Brett's office on this. We were just in front of a grand jury today. Y'all may have heard about the store owner that was murdered about 10 minutes, I guess, east of Conroe on 105. Just about a month ago, just been about a month ago now. Just a fine gentleman out there, a 19-year-old and a 13-year-old walked in there and to rob the place. It was an aggravated robbery. This whole thing lasted apparently a mere few seconds, about 16 seconds, and shot and killed the store owner, shot him in the chest, and that alone killed him there. But then, for whatever good measure on their part, as he's leaving, then shoots the guy again in the head. And the 19-year-old, we dealt with him for years. I've never dealt with him, but before I came into office, he has a lengthy juvenile history. Our file is about a foot thick on the 19-year-old. Good news is Brett gets to handle him. The 13-year-old, who was everything our investigation on, was a knowing participant. He knew what they went in there for, knew they went in there with this gun and everything. We just took his case to a grand jury today because we're seeking what's called a determinate sentence in that. I won't get into all the legalities of it, but if we want, otherwise, if he stayed in the juvenile system, we cannot certify him to stand trial as an adult because he's only 13. Texas law now says you got to be at least 14 to stand trial as an adult. So we cannot certify him and have him prosecuted with the DA's office. So we will handle it, but the most, without the grand jury's approval, the most he could get was go into kids' prison called Texas Juvenile Justice Department. He'd be locked up for about 5 years. That's all he could get for this capital murder case. So we took it to a grand jury today, seeking what's called a determinate sentence, the same juvenile prosecutor we just talked about, and asking the grand jury if they agree with us and we presented the case to them, then we can sentence him for up to 40 years, and that's the maximum you get in the juvenile system. We got the ruling back from the grand jury this afternoon. They agreed with us, and so we'll start on that case. There's no trial date or anything set on that case. So we work closely with the DA's office with the 13 and the 19-year-old. And they lived oddly enough, they lived in the Deerwood community just east of Conroe, which is one of them that I know the party is actively trying to recruit and get Hispanic voters from out in there, Marissa Runnels and some of these other ones there. And that's where these two thugs live. Any questions I could answer? I'm already on time again.
Davey, the thing I don't understand about your position is the county your client or the commissioners your client? So you represent the county, I get it, and I would sue, y'all represent me, sure, everything else. But if you have commissioners and say their advice is counter to what you think is the best interest of the county, how do you break the tie between the best interest of the county versus individual interests, which oftentimes, or sometimes at least, are not consistent with the best interest of the county? So
Right.
who's your client?
It's a good question, and we've given that a lot of thought here because we think it's a county. I assume you're specifically talking about going after this roughly $12 million. Is clearly the county's best interest for us to go after this. We have not found a way that if commissioners vote, they only need 3 votes. The county judge doesn't vote except in a tie. So if they can convince 3 of the members on the court to rescind our authority to go after it, we haven't been able to come up with a way where we could go on our own and do it, which is kind of sad because politics get involved and everything else. Because as most of y'all probably know, there was a lengthy criminal investigation involving 2 of these same commissioners at the time. The feds did it, and Red's office investigated it.
Well.
Yeah, he remembers it very well, and the grand jury ended up no bill him on the criminal side, but it's a totally different ballgame on the civil side.
That's not true. They took no action.
Yeah, that's right. Thanks for agreeing. They took no action, but they did one action. They did take. They came to Commissioner's Court and read a scathing letter, which is quite unusual, I think, to do this.
Walter's still annoyed at the letter.
Yeah, the foreman of the grand jury came,
Lloyd, how about pissed off?
read a scathing letter condemning these commissioners for what they did. So,
But JD, excuse me, Judy. But the JD, the district attorney makes a good point. That is really a tough thing, whether you represent the commissioners or who. And that, and Walker County got into it with the commissioners court, and they go back and the city attorney, it doesn't know who he's representing and all, and it's very confusing. But here's the problem I've got. Now, I'm not gonna get into the letters, but will you promise me that sometime you will, at least in a lawyer's meeting, come down there and explain to the lawyers who meet once a month down there. You came to one of the meetings, and explain to me what in the world you're doing, sending a letter out to Ed Chance, when your office is supposed to be representing it. But I won't put you on the spot again.
yeah, that gets into some legal technicalities.
Well,
Ed Chance was a former commissioner. Now, he left office, he didn't run again, and that's whose office James Nowak took, same time I came into office. You had a question?
Yes, you are set in a very difficult position. So on this case, can the Attorney General rule?
You talking about on this potential civil case here? So far, we haven't come up with any other alternatives. If commissioners vote to rescind our authority, it's the same in any case. When the county gets sued, or we want to go sue somebody, we immediately go to executive session, brief them on what the case is, and we just need permission to defend it, or permission to sue it, to pursue the case. In every single case, in seconds, we've got that. It's like, how quickly can we get out of executive session, We got the authority. This is the only case of every one of these where.
And you may be thinking that the Attorney General is a higher authority as opposed to merely being a separate authority.
Yeah, and we haven't uncovered any way they can do that. So, of course, there's a new court coming in a few months too. So
I'm not gonna vote to stop you.
I've got to say, listen, those people that are charging you for doing these things for political advantage for this side, that's bogus.
I agree. I would agree with that.
I guarantee you, I would bet my last dime that would never be in your mind at all. And I know you pretty well.
It's not. We just do the right thing.
You do what you think is the right thing.
No, they're threatening to sue me and sue the county for defamation and so forth. Kind of interesting because it's been paraded in the paper for 2 years or something on the criminal investigation, and our opinion on that is, okay, bring it on, because then it opens the door to everything that they've done.
Who represents you if you get sued? You represent me if I get sued. Who represents you?
Probably have to go outside counsel, and that's one thing I think they will probably try to do, to disqualify me in my office from, because the other side, the defendants in the case, will then sue me or sue my office. And so far, so there'd have to be outside counsel. Yes, ma'am.
It sounded, you're calling this a civil case about getting the money back and so forth. It sounds like that ought to be a criminal case because that's stolen money. Is it not?
Well, I don't know if you want to comment on the criminal case aspects
Ought
of
to be a
it.
crime.
If it's fraudulent, isn't that
Certainly
criminal?
should, and there's, the court has the ability to stop itself from doing business with vendors within the community. If those people listen to the letter, the fact that the court has been together for as many years as it has, they refuse to adopt ethics guidelines, internal rules that would criminalize that very behavior. And they refuse to pass the rules. They refused it then, they refuse it now. Only until recently have they said that they were taken under advisement to establish a committee to think about looking at those rules.
Well,
Yeah, because-
cannot a citizen
It's been 6 months ago.
say, hey, you are ignoring a
The-
criminal event? Can a private citizen
But the-
charge it?
What we're dealt with is statute of limitations. So whether or not we're conduct, the FBI had the investigation for a long period of time. And the FBI was specifically warned by me to not keep that investigation for a long period of time and then turn it over, because they were looking at federal jurisdiction and we were looking at state jurisdiction. Statute of limitations on are different for different things. And so by the time we get it, the Joe Corley facility is built in
Just, it's 5.5 years old, it's been over 5.5 years.
So, all I can tell you is that the grand jury took no action, but I can also tell you, I can only prosecute things that are within the statute of limitations. And so,
Well,
can't.
I kind of tell her, you can go direct to the grand jury. And in state court, you can talk to grand juries, don't try to federal court. You can go around the district attorney, go right to your grand jury, talk them into an indictment, and then it'll end up and he'll dismiss it. But at least you get it on the line, okay? I know how to do these things.
I've just been reminded, I broke my own rule, we were nowhere near the W's yet. I think we're only up in the L's or something. But one point on that question there, Brett, something about statute of limitations on the criminal side. The good news is, on the civil side, as a county entity, there is no statute of limitations. Now, we can't just sit around forever, it gives us some potential other defenses. But there is not a statute of limitations on what we're doing. How many more questions? One more question. Best question of the night here. Yes, sir.
Walter, my name is Aaron, A-A-R-O-N.
Yes, Aaron.
Actually, it's Walter.
Oh, my.
My name is actually Walter. One of the things that I think that I commend you and this gentleman here, and that's why we're here, is honesty and integrity. I mean, aside from all the text that you know, basic, in your biography, I think it's just great that you have the integrity and the fortitude to abide by the law, to administer it honestly and without favor, and I'm glad to see it. I mean, that's what's happening in Washington right now. Look at Lois Lerner, or whatever her name is, and Eric, I can't think of his name, the Attorney General of the United States. And they're just twisting all this around, twisting around until everybody gets tired of it and it goes away. You know, and I think, and especially if I'm not original, I'm a native Texan, I'm a naturalized Texan. I think that's great. I think that's great. I'm looking for people like you. And, you know,
Well, I appreciate that, because one thing I said during my campaign, to me, it's just pretty easy. Just do what's right and do it in the right way. And we let the chips fall where they may. And if it falls at the foot of a commissioner, so be it, or wherever it may fall. And it's just the only way I know how to do business, and that's the attitude my staff has. I know the DA's office is the same way.
Well, that's the standard too. It discourages people from trying to take advantage, if they know that up front.
I think people get
And I
it
applaud
and they
you
get away
too.
with it, so, absolutely. Well, thank you all very much. I really appreciate your time and attention.
I thank you both. You deal with such evil, and you do it so
Yeah.
well.
Yeah.
You're going to, are
And
so
you also
grateful
come-
to you both.